I'm David Mullins. I'm both a healthcare attorney and a podiatrist, and this lecture is on solving the diabetic DME problem. What is the problem? Well, I think the problem is that podiatrists have gotten very tired of both providing diabetic therapeutic shoe services and paying for those diabetic therapeutic shoe services. What is the goal for today's lecture? There is a single approach to all Medicare denials because all Medicare appeals are identical. I'm going to teach you how to apply this single approach to your diabetic DME denials. How are all Medicare appeals the same? In order to win an ALJ appeal, the answers to the same 5 questions must be understood by the administrative law judge. And it doesn't make any difference whether the appeal is about organ-contained prostate cancer or is about diabetic therapeutic shoe services. The same 5 questions have to be answered, and those answers have to be understood by the ALJ. First, what was wrong with the patient? Second, why did the problem need to be treated? Third, exactly what did you do and why was that the best clinical choice at that point in time? Fourth, how do you know that what you did was the correct thing to do? Meaning, what literature support your treatment? And 5, why is each Medicare denial reason wrong? Or why should the Medicare rule that applies to your case not be applied? What is your strongest evidence regarding diabetic therapeutic shoe services? I think your strongest evidence will always be hard copies of the digital photograph that you took when you first decided to provide the diabetic therapeutic shoe service, when you took the plaster of Paris or foam impression of the patient's feet, and when you dispensed the orthotic and the extra depth shoes. I'm not advising you to convert all your digital images of all your diabetic therapeutic shoe service patients into hard copies. Only the patients whose claims are denied after the fact with demands for repayment of overpayment. Before you could read, your parents read books to you that had very big pictures and just a few words on each page so that you could follow what was happening. It's exactly the same thing that you're going to do here with the administrative law judge. Think about the painting of the Mona Lisa. If you were trying to prove why the ALJ should award payment for the Mona Lisa, I don't think be detailing the height and width of the painting and the colors used and the details in the painting. You'd be showing the judge the picture of the Mona Lisa. That's exactly what you want to do with diabetic DME. You want to show the ALJ the pictures of Mona Lisa's feet at those 3 different times in the course of your treatment. What's the difference between a denied claim and a demand for repayment of overpayment? There is no difference. The only difference between the two is when the denial occurs. One is a denial before you get paid. The other is a denial after you get paid. What's the difference between the appeal of a denied claim and the appeal of a demand for repayment of overpayment? Again, no difference. The Administrative Procedures Act includes what is called the exhaustion of remedies doctrine. That doctrine requires you to complete a redetermination appeal before you qualify for a reconsideration appeal. And you have to complete the reconsideration appeal before you qualify for the administrative law judge appeal. How is Medicare treating diabetic therapeutic shoe services? Well, the diabetic therapeutic shoe services, as most of you know, are a listed quote issue on the Performant DME RAC website. And that means, as a listed issue, that the DME RAC can send you an additional document request, an ADR, for any diabetic therapeutic shoe service that you provide. The subsequent DME RAC audit will frequently result in a demand for repayment of overpayment because it is almost impossible to get the contractor's reporting forms completed and completed correctly in the appropriate time frames. For diabetic therapeutic shoe services, what will your redetermination appeal request include? The only thing it's going to include will be the CMS 20027 redetermination appeal request form for each patient. But what will your reconsideration appeal request include? The reconsideration request will include the CMS 20033 appeal request form plus a letter brief. What's a letter brief? A letter brief is a short letter meaning less than 3 pages in length, stapled to the attachments that support the arguments in your letter. What will the letter part of your letter brief contain? Well, of course, it's going to contain the information, the provider information, but it's also going to contain the unifying argument for all of the diabetic therapeutic shoe services provided for all of the patients in the appeal. What could an example unifying argument for diabetic therapeutic shoe services look like? Your Honor, every patient in this audit is diabetic and is under regular care for their diabetes. The attached patient photographs prove that every patient met the LCD indications for diabetic therapeutic shoe services. In addition, the attached photographs and progress notes prove the diabetic therapeutic shoe services were all provided as billed. The purpose of the Medicare contractor's reporting document is to prove that the patients are diabetic and are being seen for care on a regular basis for their diabetes. In addition, to prove that the LCD indications for the diabetic therapeutic shoe services are met and that the diabetic therapeutic shoe services were provided as required and as billed. Although some of the contractor reporting documents are incomplete, the photographs and the progress notes prove that the purpose for the contractor reporting documents were all met for each and every patient. To deny payment for these medically reasonable and necessary diabetic therapeutic shoe services would be an inappropriate form over substance denial. What will the attachments to the letter brief include? Under a separate attachment number for each patient, you're going to include first, authenticated patient photographs. Then underneath the photographs, second, a brief summary of each patient's diabetic therapeutic shoe service indications. Underneath the indications, third, will be copies of the patient's medical records. And underneath that, fourth, will be your Medicare contractor reporting documents. Whether they are complete or incomplete, you have to include them. How do you authenticate a patient photograph? On a letter-sized piece of paper, print the patient's Medicare number, the patient's initials, and the date of the photograph in the largest font size that will allow you to print each of those 3 things on each of 3 lines, and you will use that page as the background for each patient photograph. For an audit regarding many diabetic therapeutic shoe service patients, what will the ALJ appeal request include? First, it's going to include the OMHA-100 ALJ appeal request form, stapled to the OMHA 100A forms that are then stapled to your proposed decision. What's the difference between the letter brief to the QIC and your proposed decision to the ALJ? The letter brief to the QIC is your unifying argument letter that is written in your voice plus the supporting documents as attachment, whereas the proposed decision is what you want the ALJ to write, written in the voice of the administrative law judge. What conclusion do you want the ALJ to reach? Something like this. Based on the photographs and progress notes, the LCD indications were all met for every patient in this appeal, and the diabetic therapeutic shoe services were all provided as billed. The provider's evidence satisfies the purpose of the incomplete record-keeping documents required by the contractor. Payment is therefore ordered for all of the diabetic therapeutic shoe services at issue. Can you tell the ALJ this is exactly what you want the ALJ to say in the written decision? Yes. When and where can you tell the ALJ what you want the ALJ's written decision to say? Forgive me for being repetitive, but you can tell the ALJ what you want the ALJ to write in the proposed decision stapled to the ALJ appeal request form. The proposed decision will include the exact words you want the ALJ to include in the ALJ's written decision. What's the most important part of your proposed decision? The answer is the analysis. What is the analysis in a proposed decision? The analysis is always the application of the facts to the law. And the facts here are the medical facts that make up each patient's story. And the laws are the Medicare rules that apply to diabetic therapeutic shoe services. Who will write the medical facts portion of the proposed decision? You will. Assume this is a demand for repayment of overpayment, a Medicare audit, and that there are over 200 diabetic therapeutic shoe service claims in the case, and you have a PICA-appointed attorney representing you. Your PICA healthcare attorney will never know the medical facts specific to each patient as well as you do. Who should write the application of the facts to the law? Your PICA attorney will, because you will never weave the medical facts with the Medicare rules as well as your attorney will. This is what attorneys do. What will you tell the ALJ at the hearing? This may shock you, but you're going to refer only to the photographs for each patient, and you will explain each patient's problem and what you did for each patient based on the photographs, spending approximately 30 seconds on each patient. How do you spend just 30 seconds on a patient? Well, here's an example. Your Honor, Mary Smith, a 76-year-old diabetic female, was seen for a deep diabetic ulcer in the bottom of her right foot on whatever the date was. Here's a photo taken of Mary Smith showing that ulcer when she was first seen, again, whatever that date was. Here's a photograph taken on whatever the date was, showing the cast impressions of her feet. And here's the photograph taken on whatever that date was when the orthotics and extra depth shoes were fitted and dispensed. Assuming it's an audit for over 200 diabetic patients, will the ALJ let you describe the photographs for every patient? Probably not. After the first 10 or 20 or 30 patients, almost all of the ALJs, or rather most every ALJ, will interrupt you and ask something like, "Doctor, are you going to tell me that every patient file I have in front of me contains photographs and a patient summary that supports the conclusion that the indications for diabetic therapeutic shoe services were met?" When the ALJ asks you that patient, you're going to say in a very short sentence, "Yes, Your Honor," and then you're going to stop talking, because you do not want to seize defeat from the jaws of victory. When the judge asks you a question like that, the judge is cutting off the hearing because the judge understands that you have adequately provided the evidence necessary to prove you should be paid for the diabetic therapeutic shoe services at issue. Remember, Sun Tzu, who was a healthcare attorney and a podiatrist in 500 AD, said, "All battles are won or lost before the battle takes place, and all ALJ hearings for diabetic therapeutic shoe services are won or lost before the ALJ hearing takes place." Sun was right. You have to prepare for the hearing. If you prepare for the hearing, you can win the hearing. And will you feel differently after you win your first hearing that you are able to win for diabetic therapeutic shoe services? Oh, you bet you will. You will not take being bullied in the future by the biggest bully on the insurance playground, because you don't have to. Will the DME RAC feel differently about you after you win the hearing? Yes, the DME RAC will feel differently about you. Why? The DME RAC is paid on a contingency fee basis, and the DME RAC has to eat all of its costs when it loses. So assume you work at Performant, the DME RAC, And suppose you send a demand for repayment of overpayment to two podiatrists for $10,000 each for diabetic therapeutic shoe services that have been, quote, improperly paid. And let's suppose the first podiatrist cuts that check and sends it to you within a week. Let's suppose the second podiatrist appeals your demand and then beats you at the ALJ hearing. You not only have to pay that second podiatrist back all of the money that you've taken from that podiatrist's future earnings after you've demanded the repayment of overpayment, you have to pay back all of the interest as well. In addition, your costs, meaning performance costs, at researching and pursuing the appeal are costs that performant will have to eat. So yes, there will be a huge difference in how the DME RAC will respond to their loss as well. You should all take a look at the Medicare Program Integrity Manual at Section 8.2, which gives the DME RAC or the DME MAC the right to continue to pursue you if you cut that check as soon as you get a demand for repayment of overpayment, because that Section 8.2 says that Medicare can continue to go after the providers who have given evidence of improper payment in the past. Thank you. All of the information that I've provided you with today can be found in the book, How to Win Medicare Appeals. The book is published by the American Bar Association and is available on Amazon, as well as at the American Bar Association online bookstore. Thanks again.